Good afternoon. The celebrated jumping frog of Calaveras County? No idea if I've said that right. In compliance with the request of a friend of mine who wrote me from the East, I called on good-natured, garrulous old Simon Wheeler and inquired after my friend's friend, Leonardus W. Smiley, as requested to do, and I hereunto append the result. I have a lurking suspicion that Leonardus W. Smiley is a myth, that my friend never knew such a personage, and that he only conjectured that, if I asked old Wheeler about him, it would remind him of his infamous Jim Smiley, and he would go to work and bore me nearly to death with some infernal reminiscence of him as long and tedious as it should be useless to me. If that was the design, it certainly succeeded. I found Simon Wheeler dozing comfortably by the barroom stove of the old dilapidated tavern in the ancient mining camp of Angels, and I noticed that he was fat and bald-headed and had an expression of winning gentleness and simplicity upon his tranquil countenance. He roused up and gave me good day. I told him a friend of mine had commissioned me to make some inquiries about a cherished companion of his boyhood named Leonardus W. Smiley, Rev. Leonardus W. Smiley, a young minister of the gospel, who had heard was at one time a resident of Angel's Camp. I added that if Mr. Wheeler could tell me anything about this Rev. Leonardus W. Smiley, I would feel under many obligations to him. Right. There we go. That's my la-la-la's done. Let's get on with what we're here about. And hopefully this is in the right place. It's a bit too big, isn't it? We'll have to sort that out a bit. Hang on, sorry about that. I thought I had my all right, that'll do. Better. Right. An interesting case came across my reading this morning, or this afternoon, my afternoon, your morning, thanks to Rogue Nation, who was in a Discord that I'm with. He posted the writ of Certiorari. I probably pronounced that wrong again. And what I've got is I've got the original incident. I've got the sort of press release that they did about the case, and I've got the writ itself. And I'm going to just go through their summary first, then we'll probably watch the video, and then I'll go into possibly, I don't know if I'm going to read the whole writ or if I read parts of the writ. I'm not sure. Obviously, lawyers will explain it much better than I do. But yes, Alan Killian, it is time for Formula One, and my son is who moved back in with me is watching that in the other room. Let's see if yeah, they are coming up. Right. Okay. On to the article. Patriot Pickett and our co-plaintiff, Maryland Shall Issue, Inc., are appealing the recent appellate ruling in our federal civil rights wrongful arrest lawsuit, Hulbert v. Pope, to the US Supreme Court. Our petition, in legal parlance, a petition for writ of certiorari, is due for submission to the court on or before October 9, 2023. Hello. The petition is printed in booklet format and 40 copies are filed with the court. If the court grants our petition, our case will be scheduled for the filing of briefs and for oral argument. Our appeal petition to the Supreme Court is being drafted by our legal counsel, Kerry Hansel of Hansel Law of Baltimore. We are appealing the ruling by a 3-panel judge of the US Court of Appeals for the Fourth Circuit in June 2023, dismissing our lawsuit filed in the Federal District Court in Maryland in February 2018. That federal district court decided in our favour in April 2021, ruling Patriot Picket co-founder Jeff and Kevin Hulbert and our co-plaintiff Maryland Shall Issue Inc. could take our First and Fourth Amendment constitutional claims against the arresting police officer, Maryland Capitol Police Sergeant Brian Pope, to a civil jury trial. Keep up with the Formula One. Jeff Hulbert passed away from cancer 2 weeks later in May 2021. Jeff's death occurred more than 3 years after the lawsuit was filed in 2018, as the state of Maryland ignored deadlines to produce documents during discovery and fought successfully to prevent the in-person deposition of Lieutenant Governor Boyd Rutherford, whose intent to walk nearby our demonstration evidently triggered a police response to have our Patriot Picket demonstration moved for political reasons. The state's subsequent appeal of the district court decision, favourable to us, and MSI then stalled our case for another 2 years. Jeff was unable to survive the more than 5.5 years of litigation since 2018, robbed of the timely justice he deserved, having never seen a single day of our case presented to a jury in a civil trial court. Now we are appealing the unjust appellate panel decision, not just for ourselves and our fellow MSI members, but to vindicate the First Amendment rights of the public, which have been drastically infringed by the Fourth Circuit in ruling against us in the name of public safety. After Jeff Hubert's death, his estate continued as a plaintiff in the lawsuit. Jeff's brother, Clayton Hulbert, as executor of Jeff's estate, replaced Jeff as lead plaintiff by operation of law, and the title of our lawsuit was changed to reflect this substitution. The Office of the Attorney General of Maryland immediately appealed the district court ruling to the US Court of Appeals for the Fourth Circuit, citing the qualified immunity protections of police from our civil suit. Oral argument in our case was heard by the 3-judge panel at the Fourth Circuit Courthouse in Richmond, Virginia, on May 3rd, 2023, the second anniversary of Jeff Hulbert's passing. The audio-only recording of the oral arguments of our case before the 3-Circuit Judge Appellate Court panel of the US Court of Appeals for the Fourth Circuit is here. So whether we listen to that, probably not today, but that is there. The oral arguments are available on YouTube. The appellate panel's written published decision after the oral arguments dismissing our First and Fourth Amendment claims is here. After the panel's dismissal of our claims, we filed a petition requesting a rehearing of our case before all judges of the US Court of Appeals for the Fourth Circuit, citing together en banc, but our petition was denied without a poll of the judges in July 2023. I've no idea why Ellie is blocked in the chat. I will have a look at any block list. I'm not aware of why Ellie would be blocked in my chat. This dismissal of our constitutional claims occurred despite ample evidence in our lawsuit record of discovery that the Patriot Picket arrest resulted because a Maryland State Police trooper calling from Government House, Governor Larry Hogan's official residence, sought to interfere with our lawful demonstration to politically benefit an elected official, Maryland Lieutenant Governor Boyd Rutherford. Maryland Capitol Police acted on this official MSP request despite the fact Patriot Picket members were not violating any law during their demonstration and were not creating any public safety issues. Yeah. I know my last live stream, there was a response live stream, about Frauded Troll, who has gladly confirmed to all of us that he is purely an entertainment channel and you can't believe a word he says. So thank you very much, Frauded Troll. Glad to know that we know what you're about now, or clarified to some people. Now, some people won't like me going for you, but I don't really need those people around. I want people to understand that there are things that are lawful and there are things that aren't, and this is a prime example of somewhere near the line. Now, you would probably call them a frauditor. Ed Vincent, it isn't a frauditor case. Well, define a frauditor. They videoed the interaction, and we'll play that in a short while. So, what is a frauditor case? What is a frauditor? See, that's the problem with the word frauditor. Hang on, where did we get to then? The Fourth Circuit panel dismissing our claim cited the qualified immunity of the arresting officer despite the lack of probable cause for Maryland Capitol Police Supervisory Sergeant Brian Pope to make the public sidewalk arrests of the Patriot Picket members. This unjust ruling, if allowed to stand, will serve in the future as legal precedent and further empowers, arguably encourages, police at state capitals within the Fourth Circuit to arbitrarily prevent, move or drastically curtail the exercise of First Amendment rights of free speech and assembly by the public near state legislatures, simply by citing public safety. It's a case about the First Amendment, Ed. Oh, dear me. This is what gets me. This is what gets me. What defines what an auditor is? Who defines what an auditor is? Who defines? It's just. It's not a protesting case. It's a case about someone being arrested for filming the police, as we'll see. So, why is it a protesting case? Isn't that what an auditor is doing? Aren't they protesting sometimes? I just don't get the distinctions. Surely this is all about the writ of Certiorari. Now I'd have to have it up on screen to try and pronounce it correctly. Is a writ to the Supreme Court to asking them to take the case, and whether or not they take the case is up to the court. I don't know. Auditors have filmed outside government buildings for a long time. Has someone made a dictionary definition of what an auditor is or frauditor is? Not necessarily, Ed. Not necessarily. Filming outside is not necessarily filming in a traditional public forum. I don't know who this is, but it's with that comment, swing and a miss. That is a classic comment of Fraudit Wrangler. We got to get rid of these channels. They're just trash. Just trash. Sorry. This judicial decision also highlights and reiterates this bizarre legal fact. Members of the public, including the press, currently lack a First Amendment right within the Fourth Circuit to record an audio of the police in the public performance of their duties because these Fourth Circuit judges refused to rule in their published decision that this constitutional right of the public and press to record police is clearly established within this circuit. Ed, just go away and do some research on forum doctrine. I mean, look at the stupidity. This is the stupidity. I'm sorry, Ed. That's just a stupid statement. Filming the police outside in a traditionally public forum. Well, are you saying? I don't understand what point you're trying to make. Yeah, I think I'll have to start ignoring him, but it's quite interesting. And this is the point about this case, that other circuits have clearly established that right, and they're arguing that right has not been clearly established in this circuit, and the importance of the case, and we'll see whether the Supreme Court take it or whether Merb thinks, or other lawyers will think, Whether the Supreme Court might take it, I don't know. They just choose what they want to take. But it possibly would be good for the Supreme Court to rule for all circuits. As we know, Turner v. Driver did it in the, and I'm probably going to get my circuit wrong here, so forgive me. I think Texas is in the Fifth Circuit, but I might be wrong. As such, police will continue to be empowered to prevent or stop such video recording. Failing to judicially declare this right intentionally infringes on the rights of both the public and press to lawfully record video and or audio whenever police prevent, move or drastically curtail lawful political demonstrations, and police and public officials will continue to be protected by qualified immunity when doing so. Jen, yeah. What happened? I don't know if you noticed. I put the Jasper. I was right. It was the fifth. Thank you. Jen, yeah. I did put the fact that the judge had granted the stay, but I did put in my YouTube post about the granting of the stay. I queried whether it was unopposed because the stay was so so poorly written. So Denver Metro Audit's stay, that decision by the judge, and it was probably just a tick box. They looked unopposed motion. So that was granted because they believed the motion was unopposed. In fact, it's going to be opposed. It hasn't been determined yet. So they've lifted their original decision. So they've basically reversed the granting of the stay, but they haven't ruled upon it. I hope that makes sense. Who asked the question? Who asked the question? There it is again. So Jen, I hope that makes sense. It gets worse. As the published decision, this ruling in Hulbert v. Pope by this Fourth Circuit panel creates a new federal case law available to be cited as persuasive legal authority by judges in other federal circuits to infringe on the First Amendment rights of the public and press, thus empowering police in other states to arbitrarily interfere with lawful First Amendment activity and to make unlawful arrests, such as ours, without fear of civil liability. In other words, we don't have the constitutional rights in public we rightfully assume we have. Only the US Supreme Court can prevent this bizarre ruling in Hulbert v. Pope from becoming the law of the land. Our filing of a petition for writ of certiorari to the US Supreme Court does not guarantee the court will accept our case for judicial review of the Fourth Circuit panel decision. And, I mean, obviously, I've learned this over time. You all may know it. But the Supreme Court determine which cases they take and which cases they don't. So there's no guarantee that this will go forward. But it is a case which sort of they may have had the opportunity, and when we read the appeal, we'll see if it's raised. But they may have had the opportunity of denying the appeal, but clarifying some things which they're saying they haven't clarified. Yeah, the Grey Knight, yeah, he isn't in jail at the moment, no. The stay will have to be decided upon. As the question's been, and I haven't posted it because I know it's been posted elsewhere, but I will put put that back up. I will put the copy of the opposition to the stay as a community post. Unless people want it at the end of this stream, I can do it at the end of this stream. Right. A cert petition is only a request to the 9 justices of the US Supreme Court to consider granting judicial review of a lower court's decision. This is why I decided to read it, because it does sort of clarify for maybe some listeners who don't understand how this appeal process works, but it's, you know, it's quite just an easily worded explanation. Our petition will argue the published Fourth Circuit panel ruling was wrongly decided and presents an important constitutional question or issue that merits review and resolution by the court. Justices meet in private conference to vote to grant or deny the cert petition submitted to the court after the petitions have been evaluated by their law clerks. A minimum of 4 of the 9 justices, the rule of 4, is required to grant a writ of certiorari. A writ of certiorari directs the lower court, in our case the US Court of Appeals for the Fourth Circuit, to deliver the record of our case up to the Supreme Court for judicial review. If our petition is granted, the US Supreme Court will review our constitutional claims, conduct oral argument, and issue a decision. Let's watch the video and then we'll do the background. So let me switch windows. Give me a chance to have a drink as well. We want to capture that one. Want to get rid of that one. Want to get rid of that one. Right. I'll have to interrupt this a couple of times, I think, but 3 minutes 57 long. I am using someone's video here. I'll list the link in my description at the end of my stream. Oh, volume.
The sidewalk, you can actually be in Lawyer's Mall, but not on the sidewalk. Okay?
I'll call the chief up. I got his number on my phone. Or have him, can he talk?
A7,
call me.
Call APD.
Okay, well.
I got several people to arrest.
All right, he just said he has people to arrest.
So is the person holding the camera an auditor or not? Is a person holding a camera? Who defines whether they're an auditor or not? Ed.
All right, we're here on Man Up Monday, Lawyers Mall. We've been given this new directive that they want us inside Lawyers Mall. They're saying we don't have a right to the public sidewalk. Well, now they're threatening arrest. If it comes to taking an arrest, I'm taking the arrest, because every American has the right to the public sidewalk, has the right for First Amendment activity, and they don't own this sidewalk. To my understanding, this is the
So I gave you a lawful order.
public sidewalk.
Right now, I'm going to arrest all of you for disobeying my order. I told you, off the sidewalk, the Lawyer's Mall. All of them are going. They're under arrest.
What's that? Everybody else doing you guys?
Sir, I get sir. Inside Lawyer's Mall, you're going to jail.
Go ahead.
What is the cameraman doing differently than a First Amendment auditor at the moment? I don't see the difference. He's holding a camera. He's not holding a sign. He's filming, yes, a protest. He's now being given an order to leave the sidewalk. What is he doing differently?
We have a right to be on the sidewalk.
You're under arrest. You're under arrest. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. If you cannot afford one will be appointed to you at no cost. Understand your rights.
Thank you, sir. Yes. I'm convinced that this is a public sidewalk in Annapolis, and that we have the right to engage in First Amendment activity here. Once again, I believe this is First Amendment activity on behalf of the Second Amendment, but I believe that this is these are public sidewalks in Annapolis, that we have a right to be here as long as we don't impede the traffic.
Have you been told what you're being arrested for, what you're being charged with?
I'm being arrested for disobeying a lawful order. My objection is that I see this as a public sidewalk, and I'm not sure how a lawful order can be given for somebody who is using the public sidewalk.
when I saw this case, and again, the case was brought to my attention by a auditor, or some would call him a frauditor, Rogue Nation, in a Discord channel. It's reminiscent of the actions of Turner v. Driver. Obviously, at the moment, the way the decision stands, the cop has been given qualified immunity. Okay, we'll just finish off this video. As far as I can tell, this is the place where they were. So why isn't this guy being arrested? Were they moved for political reasons? Is there free speech? I don't know. I'm not saying there is or there isn't. I don't know, but I think it's a very interesting case for followers of First Amendment issues. I've been talking to myself, haven't I? You've been able to read it anyway. Doesn't matter. They got 2 criminal citations. Yeah, I'd realised I didn't put my mic back on. I do apologise for that. They got two further criminal citations. I'll just check my sound. Yeah, we're back up. Apologies for that. So they got some criminal citations, but all criminal charges against both brothers were dropped within days by the office of the Anne Arundel County State's Attorney. 12 days after their arrest, Jeff and Kevin Hulbert were joined by Maryland Shall Issue Inc. as co-plaintiff for itself as an organisation and for its individual members in the filing of this lawsuit against the MCP arresting officer and the MCP chief of police for the violation of our constitutional rights. Right. I think that's probably enough of the article. Let's start on the petition, because that's the thing that's been filed. And that's the thing that some of you may be interested in. I realise this is going to be dry, but let's have a look. They've also got someone's support to do this. Hopefully that's in the right place. So the questions presented. Whether any qualified immunity is abrogated by the notwithstanding clause of the Civil Rights Act of 1871, which provides that individuals are liable under Section 1983, any such law, statute, ordinance, regulation, custom, or usage of the state, to the contrary notwithstanding. 2. Whether the doctrine of qualified immunity is irreconcilable with the clear intent of the legislature as evidenced in the notwithstanding clause and in the historical context under which the Civil Rights Act of 1871 was enacted. Whether the doctrine of qualified immunity as developed by this court is untenable and must be abrogated as it arises from impermissible judicial lawmaking. And 4. Whether individuals have the right to record police activity under the First Amendment, a right that has never been explicitly recognised by the Fourth Circuit and which was effectively rejected sub silentio in the opinion below. And that's what I'm talking about. They could have still decided for the defendant, but they could have made this point clear. So we don't need that. So there's obviously some related proceedings. We don't need that. Oh, we don't need that. We don't need that. Oh, we're going down for a table of authorities. What's happening there with my video? It's going all over the place. Oh, hey. I obviously moused down more than I meant to there. Apologies for that. The table of authorities is interesting because you will see in the table of authorities, and obviously I'm not going to read these all out, but you will, not in the table of authorities. I did see it somewhere. Right, not in there. Circuit court cases. Is it in the circuit court cases? There we go. Turner v. Driver. So this isn't an auditor matter. This is a protest matter, but we're citing the most well-known auditor case. In this case, obviously, there's others that we'll recognise, like Smith v. Cumming. I wonder if they've got Zachary. I didn't see. No, it doesn't appear that they've quoted Liberty Freaks case there. I don't see it. It's Zachary, isn't it? I don't see it. All right. So they've not quoted his case, but Turner v. Driver they've quoted there. Keep going down, keep going down, keep going down. Right. So here we start. I've got 54 current viewers, and while I've got a number of current viewers, I'm going to... Oh, I'm off the corner there, aren't I? Oh, there we we go. That's better. Right, opinions below. The opinion of the United States Court of Appeals for the Fourth Circuit reversing the decision of the trial court is reported at, citation, and is reproduced at A1. The Fourth Circuit's order denying petitioners' petition for rehearing en banc is unreported and reproduced at A82. The opinion of the United States District Court for the District of Maryland denying summary judgment is reported at 535 and is reproduced at A38. Right, didn't really need to read all that. This court has jurisdiction to grant this petition for a writ of certiorari under 28 U.S.C. 1254 (1), which permits review after rendition of judgment or decree of a court of appeal. The Fourth Circuit rendered its judgment on June 14, 2023, reversing the decision of the trial court, Hulbert v. Pope. Petitioners petitioned the Fourth Circuit for a rehearing en banc, which was denied on July 11, 2023. This petition is timely filed pursuant to Rule 13 of this court, as petitioners filed this petition within 90 days of the denial of a rehearing. Constitutional and statutory provisions involved. The First Amendment of the United States provides in relevant part, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and petition the government for a redress of grievances. And the Fourth Amendment of the United States provides in relevant part the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. And 42 U.S.C. 1983 provides in relevant part every person who under colour of any state, statute, ordinance, regulation, custom or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit, in equity or other proper proceedings for redress. Statement of the case. Right, I'm just going to scroll this, I think, because we've read and we've seen a small bit. They were, I didn't mention that, they're a gun rights advocacy group that was protesting out there on this day. Now, I'm assuming it was a public sidewalk. I haven't looked to see, but that's been asserted and was accepted by the initial court. Right, and the cop was told he knew that there was no pre-approved demonstration was scheduled for that evening. And he only observed a single person in the area, Kevin Hulbert, who was standing on the public sidewalk in front of Lawyers Mall with a number of signs on the ground around him. So then he sought guidance, and they wanted to push them back into Lawyers Mall, I believe. We saw the pictures there. The cops wanted them to move back off the sidewalk, further away from where they would be seen. So that was the issue. They continued to demonstrate, and this is now an hour later. There were 6 people now. The legislative session wasn't due to convene for another few hours. There was no evidence that Jeff Hulbert, and the rest of his group were actually impeding the flow of pedestrian or vehicular traffic prior to being told to move to Lawyers Mall. And this was admitted by the defendant. So he told the entire group that they needed to back up their demonstration approximately 15 feet into Lawyers Mall. So away from the sidewalk, closer to the legislative building as far as I can see. Hi, Alex. I saw that snake. So the defendant repeated his command to move at least 2 more times. They didn't comply. He called for additional officers and started to place Jeff Hulbert, who he identified as the leader of the group, under arrest. Multiple people, including apparent passerby, a member of the media, and Kevin Hulbert, were filming Jeff Hulbert's arrest. Sergeant Pope directed Kevin Hulbert and 2 others who were also filming to back up. The 2 others complied. Kevin Hulbert, who I think was the cameraman in the scene we saw, did not. Sergeant Pope then placed Kevin Hulbert under arrest as well. So they were cited for disobeying a lawful order under section 1021 and released. So it garnered some publicity in the local area. And they got cited for an additional charge of refusal or failure to leave public building or grounds. So he instructed Sergeant Pope to write 2 more criminal citations. They returned to where they were that morning to do media interviews about the arrest the previous night. And that's where they were served with the further charges. And the charges were dismissed on February 9, 2018. So the initial action was filed on February 14. They raised several claims, including claims arising under the First and Fourth Amendments and common law claims or false arrests and false imprisonment. In December 2020, the defendants filed a motion for summary judgment, seeking judgment in favour of both defendants on all claims pled against them. The District Court granted the defendant's motion in part and denied the defendant's motion in part, granting judgment in favour of defendant Colonel Wilson on all claims and denying judgment in favour of respondent on 4 claims. Petitioner's First Amendment claim arising out of the Jeff Hulbert's lawful demonstration on a public sidewalk. Petitioner's First Amendment claim arising out of Kevin Hulbert's arrest while lawfully filming Jeff Hulbert's arrest. Petitioner's First Amendment retaliation claim arising out of the defendant's issuance of criminal citations without probable cause, and petitioner's Fourth Amendment claim arising out of the arrest, citation and search of the Hulbert brothers without probable cause. The District Court denied summary judgment as it concluded that factual disputes barred qualified immunity. So this is the District Court, the first hearing. They said the factual disputes barred qualified immunity, and I believe it's factual disputes, and no doubt a lawyer will put me correct on this. Factual disputes have to be, or would have been, decided by the jury. Specifically, the court concluded that there were genuine issues of material facts as to 1, whether any real, non-conjectural safety issue was aided by Sergeant Pope's actions that could support a determination as to whether a significant government interest was served by the violation of Jeff Hulbert's First Amendment rights, and 2, whether Sergeant Pope's interference with the demonstration actually served any significant government interest so as to constitute a proper time, place and manner restriction on Kevin Hulbert's First Amendment rights, and 3, whether Sergeant Pope was motivated to arrest the Hulbert brothers because of their conduct in lawfully demonstrating, given that there is no evidence that Sergeant Pope would have arrested the Hulberts if they had merely been standing on the sidewalk and not communicating their political beliefs. The Pope, who was still the case is against, filed a motion for consideration of the district court, which was denied. He then filed an appeal to the United States Court of Appeals for the Fourth Circuit. The Fourth Circuit concluded that Sergeant Pope was entitled to qualified immunity and reversing and remanding the case with instructions for judgment to be entered in favour of Sergeant Pope on all claims. Then, as we know, there was a request for a rehearing en banc, which, if I remember correctly, because that is a fairly new term to me, I know what it means. It's the whole of the judiciary in that appeal district, which was denied on July 11, 2023. I see there's an argument going on in chat, but I won't get involved. In the petition for rehearing, petitioner cited to Professor Alexander Reinert's groundbreaking scholarship on an uncodified portion of the Civil Rights Act of 1871, discussed further below, which challenged the very foundation of the concept of qualified immunity as an additional basis to challenge the Fourth Circuit's conclusion that Sergeant Pope was shielded from petitioner's claims by qualified immunity. The Fourth Circuit did not address this argument in its summary denial. All right. The foundation of the doctrine of qualified immunity is fatally flawed. So in 1871, Congress enacted the Civil Rights Act, which included Section 1, a provision modelled on a section in the Civil Rights Act 1866 that had been enacted for the express purpose of enforcing the provisions of the 14th Amendment. Citation. This statute was intended to alter the federal system in the post-Civil War era to place the 14th Amendment at the centrepiece of federal governance and cement the role of the federal government as a grantor of basic federal rights against state power. This provision, which later became 42 U.S.C. 1983, acted to open the federal courts to private citizens, offering a uniquely federal remedy against incursions upon the claimed authority of state law upon rights secured by the Constitution and laws of the nation. Citation. The explicit language of the statute, as codified in the modern United States Code, broadly applies to hold liable every person who deprives another of rights secured by the United States Constitution. Every person who, under colour of any statute, ordinance, regulation, custom, or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunity secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress. Citation. Justice Douglas has described the historical context surrounding the enactment of the Civil Rights Act as an attempt to remedy the condition of lawlessness that existed following the Civil War. The congressional purpose seems to me to be clear. A condition of lawlessness existed in certain of the states under which people were being denied their civil rights. Congress intended to provide a remedy for the wrongs being perpetrated. I'm going to interrupt the reading here again to make the point which seems to fall on deaf ears when it comes to certain idiots who watch so-called frauditors, that just because someone is exercising rights and demonstrating doesn't make them a bad person. Who determines who is bad? Morals are personal issues. What is morally acceptable differs between individuals. You might not like it, but if it's legal, what's wrong with it? You have no redress. Sorry. Obviously, the watchers of the entertainment channels, and I'm glad we now know they're entertainment channels who provide no information whatsoever. I was watching a video this morning of his that, oh dear, sorry, this is fraud to troll. He made a summation. He made an assumption, and then based arguments on that assumption. Well, you know, you weren't dealing in any facts. You were just talking out the back of your, well, you probably do talk out of your arsehole. Anyhow, the members supporting the proposed measure were apprehensive that there had been a complete breakdown in the administration of justice in certain states and that laws non-discriminatory on their face were being applied in a discriminatory manner. Then the newly won civil rights of the Negro were being ignored and that the Constitution was being defied. It was against this background that the section was passed, and it is against this background that it should be interpreted. And there's a citation. So, very few cases arose under this statute at the beginning. As Justice Scalia noted, this provision generated only 21 cases in the first 50 years of its existence. That was in 1998. As more cases began to arise under this statute towards the mid-1900s, this course faced a conundrum. What, if any, immunities applied to government officials or entities sued pursuant to Section 1983? The Civil Rights Act itself made no mention of defences or immunities. Citation. Which left this court to decide what to do with the immunities afforded state officials at common law. And that's the City of Newport v. Fact Concerts Incorporated. So the Supreme Court first tackled this issue in 1951. This is going to be interesting for me. Sorry, this is interesting for me, so I'm going to read this bit. Did Congress, by the general language of its 1871 statute, mean to overturn the tradition of legislative freedom achieved in England by civil war and carefully preserved in the formation of state and national governments here? Did it mean to subject legislators to civil liability for acts done within the sphere of legislative activity? Let us assume merely for the moment that Congress has constitutional power to limit the freedom of state legislators acting within their traditional sphere. That would be a big assumption, but we would have to make an even rasher assumption to find that Congress thought it had exercised the power. These are difficulties we cannot hurdle. The limits of Section 1 and 2 of the 1871 statute, now Section 43 and 47, brackets 3 of Title 8, were not spelled out in debate. We cannot believe that Congress itself, a staunch advocate of legislative freedom, would impinge on a tradition so well grounded in history and reason by covert inclusion in the general language before us. All right. Immunities. We do believe. We do not believe that this settled principle of law was abolished by Section 1983, which makes liable every person who under colour of law deprives another person of his civil rights. There's no indication that Congress meant to abolish wholesale all common law immunities. So I'm very speed reading this through, picking out bits because I don't want to bore you all. Let's read this bit. This court opined that a policeman's lot is not so unhappy that he must choose between being charged with dereliction of duty if he does not arrest when he has probable cause and being mulcted in damages if he does. Mulcted. I assume that goes back to mulching the fields, but ultimately this court concluded that police officers were entitled to the defence of good faith and probable cause, which arose out of common law, which came from England. Sorry. Right. So we've seen here an ever broadening of the immunity shield. But none of the immunities are contained within the statute itself. So it's all law made by the court. it does not possess the authority to create immunity were none otherwise exist. It is solely within the provinces of the legislature to create immunities. Thus, in the first few decades of qualified immunity jurisprudence, this court set the following foundations. No immunities are contained within Section 1983 itself, but the legislature was silent on abolishing pre-existing common law immunities, so therefore common law immunities that existed prior to the enactment of Section 1983 still existed following its enactment, but not all common law immunities, only the pre-existing common law immunities that do not defeat the promise of the statute, which this court may define and expand but not create, given that only Congress has the authority to establish immunities anew. It is a very thorough motion. I mean, I could have. Shall I read it all through? I'm not sure that I should read it all through. Okay. I just got a message. Maybe the person knows I'm live. I'm not sure. I might have to look at that. I wonder how much of this is new and how much of it is taken from other writs of certiorari. In 1982, this court first defined a qualified immunity that was affirmative defence with both a subjective and objective aspect. I've got the time, The Unforgiven, Yeri. I mean, I can read it in its detail, or you can read it yourself. I think reading it all is probably too much. I'm picking out bits. Maybe I'm picking out the wrong bits. A lawyer might be picking out other bits. But it's quite, it's quite an interesting actual lawyer written history of qualified immunity. Right. Legal scholars as well have noted that modern qualified immunity jurisprudence is more akin to judicial lawmaking than statutory interpretation. I'll read that again. Legal scholars as well have noted that modern qualified immunity jurisprudence is more akin to judicial lawmaking than statutory interpretation. I would say that's the very definition of how common law is made. And of course, it's up to the statutes, the legislature, which in this case, I believe, would be passing amendments to change what has been formed by common law. Thus, modern qualified immunity jurisprudence is untenable on three separate grounds. First, the derogation canon and its progeny is simply inapplicable, as recently uncovered texts have demonstrated that Congress was not silent on immunities, as had been presumed for the past 150 years. Second, even if the derogation canon is still applicable, it is fatally flawed in its application to qualified immunity. Third, even if the derogation canon did make logical sense in the context of qualified immunity jurisprudence, this court has diverged so far from the canon as for it to be unrecognisable, and modern qualified immunity is no more than impermissible judicial lawmaking that cannot substitute for Congress's explicit determination to the contrary. Interesting. So they're going a bit further than they're actually arguing against the making of qualified immunity. Two, the rediscovery of the notwithstanding clause completely reshapes Section 1983 and eradicates the foundation of qualified immunity. So we got references to a professor. But despite this court's periodic recognition that this language exists, no opinion, whether for the court or for individual justices, has construed the notwithstanding clause within the court's immunity doctrine, or more generally. Right, let's do the summary. In sum, the notwithstanding clause either 1. Provides the explicit abrogation of common law immunities that this court was looking for, but did not find in Tenney, which would destroy the entire foundation of modern qualified immunity jurisprudence, or 2. Speaks powerfully to Congress's intent that any immunity grounded in state law has no application to the cause of action we now know as Section 1983, in which case this court should nevertheless review the foundation and scope of the doctrine. Right, 3. Lower courts have recognised that only this court has the authority to resolve this issue. These issues are vital for the court to revisit, as lower courts have recognised that between the groundbreaking nature of Professor Reinert's scholarship and the significant impact a revisitation of the doctrine may have on thousands of cases across the country, only this court is situated to conclusively resolve this controversy. Given the recent publication of Professor Reinert's scholarship, this few cases have addressed the issues raised therein to date, including the import of the original text of the notwithstanding clause. The few circuit courts that have uniformly either explicitly reserved these issues for this court to decide or implicitly did so by noting these issues but declining to resolve them. So there's an excessive force case there. Roll through this. Obviously, I'm rolling at a speed that you can pause and read in detail if you wish. Is that a summary? Have they said summary? Right, there isn't any summary there. For this court is exceptionally important for this court to resolve and will continue to arise until this court has resolved it. So we're looking at this quite a lot. Obviously, a lot of reliance on this breaking scholarship in February 23. That might be worth a look, but today isn't the day. Professor Reinert's groundbreaking scholarship. All right, okay. So there was a case or a petition for a writ of certiorari, Rogers v. Jarrett from the Fifth Circuit, and that was denied on October 2nd. Apparently they're saying this scholarship has cast a shadow over every qualified immunity case that will remain until this court resolves it. This case, unlike Rogers, provides the ideal vehicle for this court to address these newly raised issues and settle the uncertainty once and for all. In Rogers, the Fifth Circuit made an alternative ruling that would resolve the case in the respondent's favour, even if this court struck down the Fifth Circuit's qualified immunity holding that Rogers failed to show deliberate indifference. The petitioner urged this court to nevertheless grant the petition, resolve the qualified immunity issue, then remand for the Fifth Circuit to reconsider its deliberate indifference holding in light of this court's decision. On his vague speculation that the Fifth Court's concurrence demonstrated the panel may have reached a different conclusion had qualified immunity not applied. By contrast, this case is narrowly tailored and ideally poised for this court to address qualified immunity without the additional complications attendant in Rogers. Here the Fourth Circuit solely premised its opinion on its conclusion that respondent was entitled to qualified immunity. Should this court find that the doctrine of qualified immunity fatally flawed and no longer applicable to Section 1983 claims, the entirety of the Fourth Circuit's decision collapses. This case would not require the court, as Rogers would have, to consider extraneous issues, although this case does also present the ideal vessel for this court to conclusively address whether a right to film police actively exists, should this court choose to do so. I'm glad that I didn't scroll through that bit. So for anyone anyone in chat has said that this sort of isn't a fraudster case, isn't an auditor case, what do auditors do? What case law is attributed to the auditing profession? Turner v. Driver, think it's Zachary or Isari, Liberty Freak. Sorry, I'm ballsing his name up. In Colorado, both have cases in those courts that have stated that as a conclusive right, the right to film police activity, but it's never been decided at the Supreme Court. A good point. Justice Thomas has aptly noted that it's vital for this court to return to the question of qualified immunity to address whether immunity was historically accorded the relevant official in an analogous situation at common law. Again, they're relying on this a lot, going to this groundbreaking scholarship. So maybe they're trying to interest the court with that, saying now's the time to do it. We've got this groundbreaking scholarship now by a professor. I don't know. Justice Thomas has urged this court to grant a petition for certiorari to revisit the doctrine of qualified immunity, given the importance of this question, and Justice Thomas continues strong doubts over the foundation of the doctrine. I wish I was an American and I'd probably know how to pronounce that. Sotomayor has noted a disturbing trend regarding the use of this court's resources in qualified immunity cases, where the court routinely displays an unflinching willingness to summarily reverse courts for wrongly denying officers the protection of qualified immunity, but rarely intervenes where courts wrongly afford officers the benefit of qualified immunity in these same cases. This approach has effectively transformed the doctrine into an absolute shield for law enforcement officers, gutting the deterrent effect of the Fourth Amendment. I'll just pick out that. This court should find significant value in revisiting these issues. Interesting. from the newly uncovered notwithstanding clause and from the historical context during which the Civil Rights Act was enacted, that Congress did not intend individuals to be effectively barred from recovery under Section 1983 by qualified immunity. So I'm assuming the new scholarly work uncovered this. Of course, the problem with going back in time to some newly discovered scholarly work is that the court actually can make its own decisions based on current practices. It can take into account perhaps what was there, but they'll do what they'll do, as we know from the abortion reversal. One Supreme Court can say one thing and another Supreme Court say the opposite. But that is precisely what's occurred under modern qualified immunity jurisprudence, from attorneys avoiding cases where possible qualified immunity issues may arise. Yeah, fair, I suppose. I mean, we're fully into abolishing qualified immunity here now, aren't we? That's what some auditors have been campaigning for. Of course, we'd have some opposers of auditors saying they're all frauds. But is that a change in civil rights that they're campaigning for? Are they all bad? Question mark. Stated from someone who is apparently on the anti-audit. Well, I say on the anti. I think I'm recognised as being fair. I'd like to think so. In sum, this case presents the perfect vehicle of review of the new groundbreaking scholarship challenging the very foundation of the doctrine of qualified immunity. This court should elect to grant certiorari in this case. Five, this case also presents the perfect vessel for this court to conclusively establish a right to film police activity. You know, this is affirming decisions like Turner v. Driver across the nation in all circuits. And they're saying the Fourth Circuit dodged this issue below. Instead of conclusively determining whether there is a right to film police activity, the court instead assumed that there was some clearly established right to film police, and then concluded that regardless of whether that right actually existed, ordering Kevin to move back less than 15 feet and film from off the sidewalk was a permissible time, place and manner restriction. The Fourth Circuit has continuously refused to rule on whether that right exists and has dodged this question not once but twice within the prior year. In a case involving the subject of a traffic stop live broadcasting in his own stop, the Fourth Circuit refrained from conclusively determining whether the right existed and instead simply emphasised distinctions between 1. Recording and live streaming, and 2. The live streaming being done by the subject of the police action rather than a bystander. And there's a citation. The Fourth Circuit then dodged the issue again in this case. Unlike the vast majority of circuits, and Turner v. Driver being one of the decisions, across the country, the Fourth Circuit has never addressed this right in a published opinion. The closest the court has ever come was addressing the issue in an unreported opinion where the court noted the right may exist, but finding that the right was not clearly established at the time, a contrary conclusion to the majority of circuits. By contrast, the First, Third, Fifth, Seventh, Ninth and 11th circuits have all affirmed this vital right. There is the very one and only Turner v. Driver. Cases that we'll recognise. As I say, we don't have, unfortunately, they haven't quoted the other case, and I forget which circuit Colorado is in, but where Liberty Freak has also got that affirmed. So, with only an unpublished opinion of the Fourth Circuit that stands against the overwhelming consensus of sister circuits, there is ambiguity and risk that trial courts will reach divergent outcomes on this issue. Leaving hook in place without firmly and conclusively holding that the right exists is, in effect, a sub silentio rejection of the right that does even more violence to the underlying right than if the Fourth Circuit had directly rejected that right in the open. With no conclusive determination in any reported case, obtaining further review will be incredibly difficult. Despite having two opportunities in the prior year to settle this vital issue, the court has instead bent over backwards to refuse to do so, to the point of resolving factual disputes as to whether the order to move served any significant government interest. Clearly, this case is an ideal vessel for standard setting as reasonable minds reach divergent results on these facts. The district court concluded that if Sergeant Pope's interference within the demonstration did not actually serve any significant government interest, then it was not a proper time, place and manner restriction on Kevin Hulbert's First Amendment rights. The Fourth Circuit reached the complete opposite conclusion, that moving Kevin Hulbert, a man who was simply filming the interaction and not interfering with the arrest of his brother in any manner, was narrowly tailored to serve a significant governmental interest. This case lands precisely at the border and will provide this court with the ideal opportunity to not only conclusively settle that the right to film police activity exists, but provide guidance to lower courts on the appropriate standards to apply when considering time, place and manner restrictions. This court should provide crucial guidance to litigants, courts, police and the general public, and clearly and unequivocally establish whether a bystander witnessing police activity in a public space has the right to use their phone to record police. And that is the petition. I've no idea how long I've been going. I know I didn't read it all out in full. Somehow I'm not going to apologise for that, because it would have made, for me, too long a stream. I could have broken it down. I've gone away from the mic, sorry. I could have broken it down. I know some people will have joined, some people will have gone. I think it's quite an interesting case. Whether this will be the one, I don't know. 1 hour and 15. Thanks, Grey Knight. For those that have been with me all through this, thank you. Go back to, for anyone that's joined us at the beginning of the case, beginning of the video, after my little reading from a Mark Twain story, only 2 paragraphs of that, instead of la la la's, I went through the press release announcing this writ, together with a video of the incident. I'll put all those links in the description to this this writ. The writ is available in Merb's Discord, so that's where you can go to get the writ, to download it. It's probably available in many other places as well. Thanks for joining me. Decide whether you want to be a tadpole or a frog leg. I'm going to dish out the numbers soon and issue certificates. So if you want a specific number, now's the time to do it. Thanks for joining me. I haven't kept up to see if there's been any arrests in the last hour or so. Auditors are being very lazy at the moment, not getting arrested. Thank you, Papa Sanzar. Someone who's just got out of jail, Corrupto Copwatch, he went in to serve a short sentence. Seems a bit messed up. But not many sort of, yeah, there'd be the odd trespass from property, but I don't do trespasses from property. That's making content for the sake of making content, in my view. And I try not to do that, or will try not to do that. Anyway, thanks for joining me. I'll catch you all again. I will put that the opposition to the stay of DMA's case. Or hang on. How many have I got? I've still got. How many have I got? Why can't I see how many I've got? Okay. Do you want me to read out the stay in Denver Metro Audit's case? I think it's 3 pages long, if I remember correctly. I can do that, or I can stop now. Up to you. Perhaps many of my viewers are asleep now, so. Right, yeah, okay. If one person asks me, I'll do it. So I've got to find it. Hang on a sec. Yeah. Let's do it so it's done, and then it's up there. I have got to download it, so you'll have to bear with me 1 sec. I don't think I've got it on my computer, so just bear with me 1 second. Oh, there we go. That's going to be easy. As you can see here, let me just move that out of the way so I can see what's on my screen. Right, as you can see here, this was the minute order stating that they granted the stay based on the defendant's apparent misrepresentation that it was unopposed. And then they've gone back in time now, because this was the order that said when a response to the motion was due, which was October the 5th. And this is the little telling off of Denver Metro Audit's attorney. The court reminds counsel that it relies on their good faith efforts and representations as officers of the court. And obviously, he'd said it was unopposed when, in fact, he had no idea. Now, the reason he said it was unopposed is probably because he didn't read the motion carefully enough. But, all right, let's get that up in size. Can we go one more? I'm just going to have to move my screen a bit. No, we're going to have to move the window over. Which window am I in? Is it that one? There we go. That's going to fit. Right. Okay. So, Christopher Cordover asked the court to stay his sentence pending appeal. The court should deny the motion, which rehashes arguments previously rejected in this case and by the Supreme Court and 10th Circuit. Factual background. On August 2, 2022, Cordova live-streamed inside the Social Security Administration office in Littleton, Colorado. Because he disregarded all signs and commands prohibiting this filming, officers issued Cordova 2 violations for petty offences. On November 22, 2022, the United States charged Cordova in a two-count information. On January 9, 2023, Cordova filed a motion to dismiss. He did not challenge count 1, failure to follow official signs and directions in violation of 41 CFR. He challenged count 2, unlawful photography in violation of another citation, on First Amendment and due process grounds. On February 27, 2023, the court denied the motion without prejudice. On March 2020, it's 10 pages, sorry, I said 3 pages. On March 21, 2023, following an earlier bench trial, Cordova was convicted of both counts. Prior to the trial, the United States noted that Cordova raised only a facial First Amendment challenge that was not relevant at trial. During the trial, Cordova renewed his challenges to count 2 on First Amendment and due process grounds. The court rejected the due process challenge in its written verdict. The court further noted that Cordova does not challenge the meaning of the regulation charged in count 1. On September 27, 2023, following extended discussions of the sentencing factors, the court pronounced a sentence of 15 days imprisonment on count 1, 2 years probation on count 2, and a $3,000 fine. Between his August 2nd, 2022 arrest in this case and his sentencing on September 27, 2023, Cordova was arrested 4 other times and charged with petty offences locally. In December 2022 and in March, August and September 2023. 2 of those arrests had resulted in convictions by the time of sentencing. 2 remain pending. In a written filing, where am I? There we go. In a written filing and during the sentencing hearing, the government argued that all 4 arrests were relevant under the sentencing factors. 2. Stay of this court, the court sentence is not warranted. The Unken factors, factors given whether the court should stay execution of Cordova's sentence. I'm still trying to work out what that's meant to say. Cordova contends that the court should base its decision whether to stay his sentence. That provision does not relate to whether to stay a sentence, but the different issue of whether the court should detain or grant bail to a defendant who is awaiting imposition of a sentence, such as whether to allow self-surrender following sentencing or to detain between a guilty verdict and sentencing. The citations. Instead, Federal Rule of Criminal Procedure 38 governs whether a court should stay a petty crime sentence. And citation, a stay is an intrusion into the ordinary processes of administration and judicial review. Oh, that is correct. It's obviously a case, sorry. I've no idea how to pronounce that. A defendant bears a heavy burden to prevent the court's sentence from taking effect. In considering a motion to stay, a court must consider whether the defendant has made a strong showing that he is likely to succeed on the merits of his appeal, whether the defendant will be irreparably injured absent a stay, whether issuance of the stay will injure other parties to the proceeding and the public interest. Here each factors disfavours a stay. B. Binding precedent forecloses Cordova's ability to show he is likely to succeed on appeal. Cordova's motion repeats arguments previously rejected about the First Amendment, the meaning of 41 CFR and the section, and the use of post-arrest conduct during sentencing. Because each challenge is not likely to succeed, the first prong disfavours a stay. In a case raising constitutional challenges, this factor of likelihood of success on the merits is often dispositive. Citation. 1. Cordova is not likely to prevail on a First Amendment appeal. Cordova asserts that he is aware of no case law across any circuit addressing the right to record in a public space. The government provided 3 such cases in response to the same argument in Cordova's motion to dismiss. Citations. Each case shows he is unlikely to succeed if he renews the same argument on appeal. And it is well settled that agencies can prohibit certain forms of expression, whether live streaming, leafleting or soliciting, on agency property when it disrupts agency business. Cordova never articulated any reason why videotaping was more valuable or less disruptive than these other forms of speech, or any reason these other cases did not defeat his First Amendment challenge, nor could he, as the government noticed in its trial brief. It is well settled that the government may, in a non-public forum, restrict use to those who participate in the forum's official business. Citation. With regard to property used to carry out specific government functions, government may reasonably reserve expression on that property exclusively for those conducting official business. It may do so through regulation, as GSA did here, or policy, as SSA did. And citation. Cordova's First Amendment argument runs counter to overwhelming Supreme Court and Tenth Circuit precedent and is not likely to succeed on appeal. 2. It was not clear error to find Cordova filmed in space occupied by an agency, and he had fair notice his conduct was unlawful. Cordova next disputes his conviction under 41 CFR section, contending that 1. The court erred in finding he filmed in space occupied by an agency, and even if it was not error, 2. Cordova may have reasonably understood it to be a lobby. Each contention is meritless. First, Cordova cannot show, as he would be required to do, that the court clearly erred in its factual finding that he was filming in space occupied by an agency. On appeal, the factual finding that Cordova was filming in space occupied by an agency, rather than space is not occupied by an agency, is reviewed for clear error. Citation. He cannot meet the standard when the written verdict makes detailed factual findings before concluding that Cordova was filming in a space where the agency conducted its business. Second, he is incorrect that the question is whether a reasonable person may have viewed it as a lobby, and the court rejected this argument. As the court squarely held, the issue is not whether a reasonable person would have had notice that the conduct was lawful, but whether Cordova had fair notice. Citation. He did. It is clear based on the regulation, the signage in the SSA entryway, the instructions given by law enforcement, and Mr. Cordova's own understanding of the law, that he had fair notice of the law and that his conduct in filming beyond the interior glass doors was punishable. Baldwin means that Cordova is unlikely to prevail if he raises the same argument on appeal. 3. It was not error for the government to recommend incarceration based on new arrests. Cordova contests the government's request for incarceration based on 2 post-conviction arrests for misdemeanor offences because he has found no case law to support the principle that a court may impose imprisonment on the basis that a defendant has been charged with a separate offence for which he has not been convicted. But it is routine to consider post-arrest or post-conviction conduct at the time of sentencing, regardless of whether it has resulted in a conviction. Citation. Finding post-conviction conduct may be highly relevant to several of the Section 553(a) factors because it provides the most up-to-date pictures of a defendant's history and characteristics and also sheds light on the likelihood that he will engage in future criminal conduct. Citation. Lent extended the principle far beyond this case by finding post-sentencing conduct review relevant even if a resentencing occurs long after vacatur of a previous sentence. For similar reasons, courts can consider other arrests even if they result in acquittal. Citation. Sentencing principles do not require courts to turn a blind eye to known information about a defendant, such a rule would disserve the public by undermining sentencing purposes, such as whether the defendant is likely to reoffend if not given a sentence of imprisonment. Citation. And surely part of his post-offence behaviours was his wearing those socks. If you've seen the picture, it is laughable. Indeed, Congress has made explicit that it is an error to place such limitations on the discretion of a sentencing judge. Citation. No limitation shall be placed on the information concerning the background, character and conduct of a person convicted of an offence which a court of the United States may receive and consider for the purpose of imposing an appropriate sentence. C. Cordova cannot establish irreparable harm because he has not challenged his conviction for count 1. At sentencing, the court imposed 15 days imprisonment for count 1. Interesting. Failure to follow official signs and directions. Cordova cannot establish irreparable harm because he has not challenged his conviction for count 1. He was sentenced to 15 days on count 1. And he got sentenced to 2 years probation on count 2. So if he hasn't opposed count 1, for which he got 15 days, how can he arguably stay that bit? Although Cordova proffers 2 bases for his appeal, both relate solely to count 2. Thus, even if he prevailed on appeal, it would at most require vacatur of his term of probation under count 2. It would not extend to count 1 and his obligation to serve 15 days imprisonment. Because appellate, I should read that before making my own statements because, of course, they have laid it out. Because appellate success would not affect his prison term, he cannot show irreparable harm from an order to serve that term while he appeals. Citation, allowing defendants to separately move and courts to separately consider whether to stay imprisonment, fine, or probation. D. The remaining Unken factors do not support a stay. Granting a stay would harm the interests of the United States and the public by eliminating the safeguards put in place to protect the public from further crimes and deter criminal activity by a defendant who has shown a likelihood of reoffending. In the span of 13 months between August 2022 and September 2023, Cordova was arrested for committing petty crimes on 5 dates. The public interest does not support staying the sentence of someone who has demonstrated time and again he is likely to reoffend if not given serious consequences. If the defendant is continuing to commit crimes, implementation of the court's sentence of incarceration, a fine and probation are appropriate. They also align with the public interest of ensuring that criminal offenders serve their sentences in a speedy manner. Even if the defendant were irreparably harmed by the execution of his sentence, his failure to make a strong showing of success on the merits and interests of the United States and the public would prevail. The Supreme Court has made clear that irreparable injury alone does not require a stay. Citation, a stay is not a matter of right, even if irreparable injury might otherwise result. Citation, stating that demonstration of irreparable harm without more is not sufficient to justify a stay. 3. Conclusion. The Unken factors do not warrant a stay of Cordova's sentence. He cannot show a likelihood of success when binding precedent forecloses his grounds for appeal. The government requests the court enter final judgment and order Cordova to begin serving his sentence. That includes imprisonment, payment of a fine, and probation. And that was submitted. It's actually submitted on the 3rd. I'm not sure what date it hit Pacer. Anyhow, so we're still open on his request for a stay. This motion looks far better written than the defendant's motion, but I'm no lawyer, so I have no idea who will prevail. Thanks for watching my rather long stream. My reasons for going through that other case were its implications that possibly a case that could clarify across all circuits the right to film police.